Talking to Cornelius. Conversation 17. The story of your courtroom drama really tells itself, old man, thanks to the extensive coverage of the Hobarton Guardian or True Friend of Tasmania. It's unclear whether you were in the courtroom on the day of the trial. I suspect you may have already crossed Bass Strait to Victoria by then. Your brother James was certainly there, along with your barrister, Edward McDowell. Philip Stanley Tomlins, Justice of the Peace and petty magisterial tyrant of the Huon district, was sitting at the other table as a self-representing defendant. The matter was an action for false imprisonment. You and James had been locked up by Tomlins for 8 days at the watch house in Franklin, and then a further 3 days at the watch house at Browns River. Tomlins imprisoned you because you didn't have certificates to prove your claim that you were free men. Your own lawyer, Edward McDowell, presented an interesting point that revealed something about you in his opening remarks. Within a day or a week before this very occurrence of false imprisonment took place, the plaintiff, he's talking about you, old man, was brought before the defendant, Tomlins, on a charge of using abusive language to a constable and with being drunk. And this man was then fined by Mr. Tomlins, and properly fined. He did not dispute it, but he would have the jury judge that the defendant then treated his client as a free man, although afterwards he meets him upon the high road, treats him as a felon, and causes his removal to a watch house. Of course, the point of the argument was to establish that Tomlins had full knowledge that you were a free man before the day that he falsely imprisoned you. But still, through McDowell's argument, we nevertheless catch sight of you, old man, with more than a drop of grog in your system, throwing caution to the wind and mouthing off at the local constabulary. And I suspect that's exactly what the local constabulary wanted. Everything I read suggests the convict constables were more often provokers of unrest in the hope of extracting a fine, rather than keepers of the peace. But still, old man, it's probably good you left the local area for a while. At this point in the proceedings, your brother was called up as a witness, and we finally get to hear the direct voice of at least one of the Donnelly brothers. James Donnelly, brother of the plaintiff in this action, was then called. He stated that in the early part of the month of June last, he was residing on the Huon. Witness recollected the 10th of that month, and knew the defendant, Philip Stanley Tomlins. Witness and his brother met the defendant as he was coming up from the watch house. The defendant first of all passed by and then called after them. Witness, being the last that passed, turned around. The defendant then said to witness, "It seems to me you don't know the proper respect which is due to a gentleman when you meet him." Witness told defendant he did not think that he was entitled to any more respect than any other man. The defendant then said he would see and asked witness who he was. Witness told him he was a free man. The defendant then asked him how long he had been free. Witness told him since the 9th of last October. He next asked witness how long he had resided on the Huon settlement, and witness told him about 18 months. He then asked witness if he had got his parchment certificate with him. Witness said he had not, but told him that he had not taken it up yet. The defendant then told witness to go along with him to the watch-house. On proceeding a few steps, the defendant then called a constable and gave witness in charge. The defendant then turned round to witness' brother, the plaintiff in this action, and asked him what he was. He replied that he was a free man. The defendant then asked him what he had got to show for being such, and he replied, "Nothing at present." The defendant then asked him where his parchment was. The witness' brother made answer that he had not taken it up yet, but he had applied for it. The defendant then said to the constable, "Take this man in charge also," meaning witness' brother. That constable's name was Cooper. Witness and his brother were then taken to the Huon watch-house. This was on the 10th, and they remained there until the morning of the 18th. Witness did not see anything of Mr. Tomlins during that time. On the morning of the 18th, witness and his brother were taken to Browns River. They went in custody with Constable Lowe. Witness and his brother were both handcuffed. About 1 or 2 o'clock, they reached Browns River and were conveyed to the watch-house. They remained in custody at Browns River until the 21st, when Mr. John Joseph Fleetwood, the district constable, let them go. Neither of them were brought before Mr. Tomlins. Cross-examined by the defendant in person. Witness resides with his brother on Mr. James Thorpe's land on the Huon settlement. Witness rents 8¼ acres of ground from that gentleman and earns his living by cultivating it and working in the bush occasionally. The rent of the land is £5 a year. Defendant: Where did you get the money to bring this action? His Honour: The action is brought by his brother. Defendant: Ah, so it is. Well, where did your brother get the money from to bring this action? Witness: Part from my father. Defendant: Where did you get the rest? Witness: Borrowed it. Defendant: Who from? Where did he borrow it? Witness: From Mr. Thorpe. Defendant: When are you to repay it? Witness: When we are able. His Honour: Are the damages mortgaged then? Defendant: Any amount of the produce of this 8¼ acres? Witness: Perhaps not, for we might give him shingles. Defendant: Did you either write or cause to be written a letter to the government complaining about this matter? Witness: I did not write, nor cause one to be written. Defendant: But you know there was one written. Witness: I was told so. Defendant: You were told so. Oh, very good indeed. You were told so. Capital. But you did not know anything about it, eh? Very good. Now, what I want to know is how it is that you do not bring the action as well as your brother. Mr. McDowell: He thinks probably that one party to the action is quite enough for you. Defendant: Oh, well, but never mind. By the by, have you got your certificate yet? Witness: I went yesterday for it to the Controller General's office. Defendant: Ah, you went yesterday to the Controller General's office. Very good. You say you have been living, if I remember rightly, down at the settlement for 18 months. And, of course, you are cognizant of the occurrences which have taken place there. Do you remember Mr. Thorpe, who has kindly lent you this money, having been fined for the illegal selling of wine? His Honour laughed and said the question was an irrelevant one. Mr. E. McDowell: Oh, let him go on. Here the defendant resumed his seat in despair and discomfiture. The following additional witnesses were then called in rotation: Mr. James Manton, acting police clerk at Browns River, and Mr. John Joseph Fleetwood, district constable at Browns River. The defendant put some question to the last witness, which Mr. McDowell said was quite irrelevant to the case, as it referred to the conduct of some young woman. He then put some other question when His Honour checked him. The defendant next apologised to His Honour for not understanding the rules of cross-examination, whereupon His Honour said, "Then you should fee some counsellor to plead for you, sir." Mr. McDowell here intimated that the case had closed against the defendant, who addressed the court very vehemently, denied that he was a despot, as insinuated by the counsel for the plaintiff, whereby not only justice of the peace but even a constable is authorised in apprehending any man whom he reasonably suspects of being a convict, illegally at large, etc., etc. He had only done his duty in a matter which he thought would be approved of. In offering the plaintiff £5, which he did, he so offered it, not that he thought he had done wrong, but for this reason: to endeavour to save the court the trial, or the jury the trouble of deciding the question. If he had done less, he would have been wanting in that energy and firmness which alone could keep such a district as the Huon in anything like order. He had no witnesses. His Honour then summed up, directing the attention of the jury to the plea of the general issue. He further said, there was no law to compel any man to take up his parchment certificate of freedom unless he thought proper. The jury immediately found a verdict for the plaintiff. Damages, 1 farthing. Hobart and Guardian, 17th of September 1851. You went to court hoping for a £200 payout, old man, and you were given 1 farthing. I suspect the ambivalent outcome said a great deal about the Vandemonian justice system in your day. The form and due processes of justice were maintained, but the practical application was all about asserting a certain social order. Who did newly emancipated convicts think they were, taking magistrates to the Supreme Court? But a greater justice soon caught up with old Philip Stanley Tomlins. His life went into a downward spiral after your court case. Huon District. Dismissal of Mr. Tomlins. The Assistant Police Magistrate of this district is now vacant. On the occasion of a complaint from the Chief Police Magistrate, Mr. Tomlins was directed to hold himself in readiness to remove to Bothwell. In reply, he stated he did not wish to embarrass the government until the elections were over, and that he should resign at the end of the month. But his resignation was couched in such violent language that it ended in his dismissal. In the Government Gazette of yesterday the following appears: the Lieutenant Governor has been under the painful necessity of dismissing Philip Stanley Tomlins, Esquire, from the office of Assistant Police Magistrate at the Huon, and of causing his name to be erased from the Commission of the Peace. Hobart and Guardian, 29th of October, 1851. He disappeared from view after a failed attempt to re-establish a career in Victoria. It was 16 years before Tomlin's name was mentioned again. A letter by a recent mail from the Mauritius mentions the fact that Philip Stanley Tomlins, once well known both in Launceston and Victoria, is dead. A letter from Port Louis, dated 4th of April last, has the following passage. I was much shocked to hear yesterday that Tomlins was dead. He went on board a brig called the sea nymph in order to get something to eat. He was nearly starving, and on coming on shore fell down on the wharf and was picked up by some bystanders and conveyed to the hospital, where he died in about an hour and a half after admittance. Captain Fisher, owner of the brig, paid all the funeral expenses, although a perfect stranger to the old man, unless sometimes meeting him in Fremantle constitutes an acquaintance. Tomlins was interred in the Western Cemetery, Port Louis, on April the 3rd, the day following his death. The captain and I were the only persons who followed him to the grave. The writer added that, though they said at the hospital that the deceased died of fever, he believed that death was really caused by apoplexy, consequent upon intemperance. The deceased, who was possessed of considerable abilities, once occupied the position of police magistrate in Tasmania, from which office his habits compelled him to retire. He next went to Victoria, and Mr. Mitchie, the then Attorney General, was on the point of giving him an appointment as police magistrate when a fit of intemperance disqualified him. Subsequently, he was clerk of petty sessions at Echuca, and latterly came down in the world considerably. He sailed for Mauritius in the Hannah Nicholson some months since. Launceston Examiner, 8th of June, 1867.